Good evening, everyone, and welcome to the launch of Volume 47, Issue 3 of the University of New South Wales Law Journal. On behalf of the Journal, I would like to begin by acknowledging the Gadigal peoples of the Eora Nation, the traditional custodians and owners of the land on which we gather this evening. We pay our respects to elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people joining us this evening. My name is Hon Marcia Neave AO, and I am the Executive Editor of the University of New South Wales Law Journal for 2024. It is my immense privilege to commence tonight's official proceedings for the launch of Volume 47, Issue 3 of the University of New South Wales Law Journal, a general issue containing 10 articles on the topic Access to Health, Law and Justice, Opening Doors and Overcoming Barriers. The UNSW Law Journal has always spotlighted and investigated contemporary legal matters which can impact some of the most vulnerable people of our society. Issue 47.3, despite being general in nature, certainly captures this key characteristic of the journal. From investigating coercive control legislation to gender-affirming care, and even tackling the use of electric prodders on rodeo horses, Issue 47.3 is a prime example of what the journal does best, exploring a variety of legal matters that affect all members of the community. Of course, we would not be here tonight but for the excellent authors whose work comprises the 360 pages of Issue 47.3, some of whom we are thrilled to welcome here tonight. Thank you for entrusting the journal with your academic works and for contributing to discourse on contemporary, important, and moving legal topics. In responding to such a well-rounded issue, I would like to welcome and thank the Honourable Marcia Neave, Chair of Justice Connect, part-time Commissioner of the Australian Law Reform Commission, and former Justice of the Victorian Court of Appeal, who will be delivering tonight's keynote address on the journal's topic. Next, applause must be given to our brilliant and diligent student editorial body. Being a student means having a plethora of commitments to live up to, whether that be multiple uni classes, assignments, work and life commitments. The 35 students which make up this editorial board have managed to come together and create a publication extremely complex and meaningful. This launch is truly a testament to each editor's diligence, commitment, and earnestness. The hard work of the Executive Committee must also be recognised here, currently consisting of 6 issue editors, 1 forum editor, and 1 digital editor. Running a journal often reminds me of parallels to Jenga, where each block of the tower is the remarkable knowledge, good humour, and grace of every editor, without which the whole thing would topple over. And of course, this launch would not be possible without the editor of Issue 47.3, Jack Yasuda. Jack holds the honour of being the board's only Canadian issue editor, an honour truly remarkable as he has certainly mastered all the principles of the Australian Guide to Legal Citation. In the best way possible, Jack upholds much of the stereotypical characteristics of Canadian ideals. He is the epitome of politeness, kindness, good humour, and is the steadiest of hands to rely on. We always know that we can count on Jack to lend a helping hand. We are incredibly excited to see what you achieve next, Jack, and are pleased to welcome your successor, Sophie Nguyen, who has already proven she is up to the challenge. My thanks also goes to the UNSW Faculty of Law and Justice. In particular, our 2 SAGE faculty advisors, Professors Rosalind Dixon and Gary Edmond, who are quick to remedy any pickle, and Professor Andrew Lynch, Dean of UNSW Law and Justice, who is here tonight and always champions the journal's achievements. Lastly, but definitely not least, I would like to thank and recognise the extraordinarily generous contributions of the journal's premier sponsors, Allens, Cause Chambers Westgarth, Herbert Smith Freehills, and King & Wood Mallisons. Most importantly tonight, we would like to thank Allens. This launch would not be possible without the continuous support of the firm hailing as far back as 1981. Allens has continued to maintain its unwavering support for the journal, and without it, the journal would not be able to maintain its status as one of Australia's leading academic law reviews. And for that, we are ever so grateful. Thank you all for joining us tonight for Issue 47.3's launch. It is now my pleasure to invite Simon Soljo, partner at Allens, to speak on behalf of the firm.
Thank you very much, Sharanya. I'm a partner here at Allens in the financial services and regulatory team, And I'd like to acknowledge also the traditional owners of the land on which we meet today, the Gadigal people of the Eora Nation, and I too pay my respects to their elders, past and present, and extend that respect to Aboriginal and Torres Strait Islander people with us tonight. It's my great pleasure to welcome you all here this evening to the launch of this latest edition of the UNSW Law Journal. I'm particularly pleased to have the opportunity to welcome you as a graduate of UNSW Law School myself and a current member of the UNSW Law and Justice Advisory Council. I would particularly like to welcome the Honourable Marcia Neave, who will be delivering tonight's keynote address. To say that Ms Neave has had an illustrious career is quite an understatement. Spanning several decades, her work has included significant contributions to law reform, public policy and academia. She has served as a judge of the Supreme Court of Victoria, Court of Appeal Division, and was the Commissioner of the Victorian Royal Commission into Family Violence. In addition to her judicial roles, Marcia Neave has been a professor, including at ANU, Adelaide and Monash, has held the position of President and Commissioner of the Commission of Inquiry into the Tasmanian Government's response to child sexual abuse in institutional settings, was the inaugural chair of the Victorian Law Reform Commission, and is currently a part-time Commissioner of the Australian Law Reform Commission. Her work has had a profound impact on modernising laws, particularly those addressing systemic disadvantages faced by women and children, which of course makes her a perfect choice for tonight's address, given the theme of the UNSW Law Journal's latest edition. As Shamanya said, the association between Allens and UNSW Law Journal is a long and cherished one. For over 40 years, our firm has been a proud supporter, recognising the vital role of the journal in the legal community. Indeed, many of our past and current lawyers and partners have walked this path, contributing to the journal as writers or editors, or in the case of some particularly conscientious students, both, during their formative years. The journal, of course, is renowned for its scholarly excellence and has rightly earned its place in the legal landscape, consistently providing insightful and influential articles that shape legal discourse. Its reputation for rigorous peer review and high academic standard makes it a dependable source of legal scholarship, and naturally those are the same qualities we seek out in the excellent students who become valued colleagues with us here at Allens. And this latest edition is no exception. Access to health, law and justice, opening doors and overcoming barriers could not be a timelier topic. This edition addresses the systemic challenges that have long pervaded our society, but which now ever more urgently demand our focused attention and concerted effort to help alleviate the burdens faced by our most vulnerable. The scholarly work reflected in this journal will help to shed light on key challenges as well as potential solutions to fostering a more just and inclusive society. So again, welcome all, and congratulations to everyone involved with this edition, especially the UNSW Law Journal Editorial Board and Jack Yasuda, the Editor-in-Chief, who I now invite up to speak.
Thanks so much, Simon, for that lovely introduction, and to Allens for hosting this launch and giving us such a great opportunity to celebrate the incredible work being published in issue 47.3. And also just to Allens for being such a long-time, steadfast supporter of the journal as one of our premier sponsors. Thanks as well to all of you for coming out and giving up part of your Wednesday to be here for the launch of issue 47.3 of the UNSW Law Journal. I'd like to start by going back in time a little bit to January 26, 2022, which is a seemingly unremarkable day, but this was actually the day that I arrived in Sydney to begin my law school career. And through the sequence of events that has transpired since then is part of the reason I'm here speaking to you all today. Now, the more perceptive of you may recognize that January 26th actually isn't an unremarkable day, but it's actually Australia Day. Admittedly, coming from Canada, I didn't really recognize the significance of this date when I first arrived, but now having been here for almost 3 years, I have a much deeper appreciation for and understanding of the role that this date plays in Australia's colonial history. As the arrival of the First Fleet in 1788, the myth of Terra Nullius, and countless other systemic and institutional efforts by the state since then have contributed to the ongoing marginalization of Aboriginal and Torres Strait Islander peoples. And I bring this up because any launch themed around access to health, law, and justice, as this one is, would be fundamentally incomplete if it didn't recognize the impact of the ongoing colonial project on the ability of Australia's First Peoples to access health, law, and justice. It's not until these effects are acknowledged and addressed that reconciliation, however we define that, can even begin to be achieved. On that note, I also would like to recognize that we are meeting on the land, the unceded land of the Gadigal people of the Eora Nation. I pay my utmost respect to their elders, past, present, and emerging, and extend that respect and acknowledge any Aboriginal or Torres Strait Islander people here tonight. This land always has been and always will be Aboriginal land. So as I alluded to, this issue addresses the theme of access to health, law, and justice, opening doors, and overcoming barriers. The beautiful and sometimes difficult thing about a general issue like this one is that you never quite know what articles are going to come through, which can be nice in that it allows the issue to cover quite a vast range of legal topics. But it can also make it difficult to pick a launch theme as you try to find one or more threads that try to link the articles together. Despite this randomness, though, all 10 articles in issue 47.3 kind of organically came together to tell a very interesting and coherent story. Some people may chalk this up to sheer coincidence, and others may simply think that I intentionally chose a very broad theme to make them all fit. And those are probably both true to an extent, but I also think it's a testament to how important health, law, and justice are to a person's life. In recognizing that, though, it's also important to recognize that not all people can or do access them equally. Doors are often closed to underrepresented groups, such as the LGBTQIA+ community, children or victim survivors of domestic and family violence, to name a few. And they're often faced with more significant systemic barriers, which make the path to accessing health, law, and justice far less straightforward than it should be, and far less straightforward than it is for other members of society. It is therefore crucial that we continue to question the medical, political, and legal norms which allow these patterns to persist, and that we find ways to eliminate the obstacles they create, which is a task that is very valiantly undertaken by the articles in this issue. In certain respects, there is also probably perhaps no better forum through which to consider these issues than the UNSW Law Journal. The founding dean of UNSW Law and Justice, Professor Hal Wooten, expressed that, quote, "A law school should have and communicate to its students a keen concern for those on whom the law bears most harshly," close quote. This philosophy has kind of is now part of the furniture of UNSW Law and Justice, both figuratively in that it's quite deeply ingrained into the university's pedagogical approach, but also literally in that there's like an actual big banner in the lobby of the law building which displays this quote. The articles in this issue then take this philosophy and extend it beyond the law school classroom and try to they truly embody this philosophy and consider new ways of promoting access to health, law, and justice to better support often underrepresented groups. Access to health occupies the first 3 articles in this issue, beginning with Ruthie Generett, Eliana Close, Lindy Wilmot, and Ben P. White's article, which considers how patients and family caregivers can serve as regulatory actors within Victoria's voluntary assisted dying landscape. They map the actions, motivations, and outcomes, as well as the intrinsic and extrinsic factors affecting those actions, motivations, and outcomes, which all contributed to these parties' ability to regulate the system and effectively remove, or at least mitigate, the barriers to accessing voluntary assisted dying. Gabrielle Wolf then analyzes international legal responses to the debate regarding gender-affirming medical treatment for trans and gender-diverse minors. She finds that different jurisdictions in the West have adopted different approaches, which can result in uncertainty for minors, parents, doctors, and even courts about who can make decisions about gender-affirming treatment and how they should go about doing so. Moving to issues concerning mental health, Aisha Ziad and Kelly Burton argue for the implementation of trauma-informed practices within the law school curriculum in order to try and mitigate the effects of sensitive course content. They argue that this will not only promote law student mental well-being in the short term, but will make students more employable and destigmatize conversations about mental health in the legal profession. Shifting now towards law, Jane Wangman, who is here tonight, critically analyzes the newly enforced legislation which makes New South Wales the first Australian jurisdiction to criminalize coercive control. Wangman walks through the offense and posits that while it is the step in the right direction in the recognition of coercive control, the law is underpinned by certain misconceptions of it, which may threaten the law's effectiveness. Moving from the legislature to the judiciary, David Hamer critiques the High Court's approach to probative value assessments in criminal cases. He finds that the High Court has often approached probative value very holistically or together with other evidence, as opposed to atomistically or focusing on the challenged evidence in isolation. This, he argues, introduces incoherence into the law and risks the judge trespassing onto the jury's territory as finder of fact. Kylie Lingard, who is also here tonight, then looks at Part 7, Division 3 of the Crimes, Appeal, and Review Act, which provides a pathway for convicted persons to apply for a conviction or sentence review. Lingard analyzes Part 7 decisions between 2014 and 2023 to provide an understanding of the effectiveness of this pathway, as well as to shed lights on some of the challenges that exist for applicants who pursue it, such as a lack of clarity in the application, a lack of understanding of the legal requirements, and the inability to access legal assistance. Taking a step away from humans for the moment, Morgan Stonebridge, Di Evans, Jane Kotzman, and Andrew McLean consider access to justice issues for rodeo horses. Specifically, the authors considered the use of electric prodders on rodeo horses, which is permitted in certain Australian jurisdictions, as opposed to race horses, where the use of electric prodders is prohibited. The authors consider whether this comparative lack of protection for rodeo horses can be justified, ultimately arguing that the use of electric prodders on rodeo horses should be made an offense in all jurisdictions. In a similar vein of comparison, but returning back to humans, Michael Duffy and Soulette Lombard compare the use of third-party litigation funding in insolvency versus class actions. They draw attention to certain distinctions that exist between them, such as the nature of the parties involved and the role of the courts, which they argue should be kept in mind in any future attempt to regulate third-party litigation funding. Sticking with class actions, Brandon D. Stewart uses the Canadian Freedom Convoy class action to assess a hypothetical battery claim for intentional noise exposure. Stewart considers whether battery ought to respond to noise-related interferences, as well as whether noise could satisfy all necessary elements of battery. He argues that not only are the principles of battery applicable to noise exposure, but battery may actually serve as a more appropriate pathway to achieving justice than other torts such as negligence or nuisance. Rounding off the issue, Ashwini Ravindran, who is also here, critically analyzes the High Court's decision in Alexander and Minister for Home Affairs and queries whether Section 5119 of the Constitution, known as the Aliens Power, can be used to involuntarily deprive a natural-born Australian of their citizenship. Ravindran argues that conduct alone can neither bring a citizen within the scope of the Aliens Power, nor amount to repudiation of citizenship, ultimately endorsing a more enduring concept of what it means to be an Australian citizen. Having now walked through all 10 articles in this issue, I have to admit I struggled quite a bit writing this speech because there are so many things I can say about the past year and about this issue, and I wasn't quite sure how I was going to condense it all down to 15 minutes. I had some ideas, I wrote stuff down, and there was actually more than one occasion where I thought I had my breakthrough. Finally, I had what I thought was my final version, and then I read it back to myself, and I was like, oh, it's good enough for jazz, I guess, which is actually the point where the light bulb went off in my head, and I said, oh, I think I can run with that. So here goes nothing. So for those of you who aren't familiar with the phrase good enough for jazz, it's used to communicate when something is good enough without needing to be perfect. Without kind of getting too much into the weeds of the phrase, because it's a law journal and not a linguistics journal, I imagine its origin comes from the fact that jazz is viewed as this sort of inherently loose or imperfect genre. And I imagine it was probably first used disparagingly to describe some sloppy tuning or less than perfect adherence to melodies from jazz musicians. In my opinion, though, the connotations of this phrase kind of get it all wrong, because it is precisely these imperfections and the roughness of jazz that makes it so beautiful. And I think what makes it serve as quite a nice analogy to the publication of this issue. Because when I think back about the past year, I'm not going to remember it as this time where everything went right and it was completely seamless. To the contrary, what I will remember most about my time as editor of this issue will be the bumps in the road. It will be when things weren't going quite according to plan, or being counseled by my fellow executive committee members and friends when stress was at an all-time high. These are the things that have made the past year so great and so memorable. And these imperfections in the process are what make the publication of this issue all the more special and all the more beautiful. But the analogy extends beyond that. The articles in this issue are like 10 pieces of music in a set list, each contributing something unique and special to the whole of the issue. The issue's 18 authors act as composers, applying their experience, passion, and scholarly prowess to create interesting and thought-provoking work. So to these authors, I extend a sincere thank you. Firstly, thank you for trusting us, a student-run journal, with your article. Thank you for your patience, understanding, and generosity throughout the publication process. It has been an incredible honor to work with you all, and I just hope that we have done right by your work. There are, of course, also individuals who work behind the scenes, but without whom the publication of this issue would not be possible. So I'd like to thank our typesetter, Carrie Cook, and our cover designer, John Hewitt, as well as the printing team at Laguerre, for making sure the issue is as visually stunning as it is intellectually stimulating. I also want to thank the journal's faculty advisors, Professors Rosalind Dixon and Gary Edmond, for their support and wisdom in helping us navigate the complex world of legal academia. I'm also deeply appreciative to Professor Andrew Lynch, Dean of UNSW Law and Justice, for being such an outspoken supporter of the journal, and dare I say, our biggest fan. The journal is incredibly lucky to have such strong support from the faculty, And we take immense pride in knowing that it will always have our back. If I may push my luck a little bit and return to my analogy for a second, before I beat it to death. One of the staples of a good jazz ensemble is the ability of the supporting musicians to listen to what the soloist is doing and adjust the way they're playing to make it sound like they rehearsed it this way, when really the soloist could be doing something totally out of left field, and everything could be going sideways. In this scenario, I am, of course, the rogue soloist going off on a frolic of my own, and the editorial board are the musicians trying to adjust to my lunacy and make sure it doesn't come through on the pages of the issue. So to the editorial board, thank you. From my countless emails to your late nights of editing, to our spirited discussions about AGLC rules, I can't express how truly grateful I am for all the work that you guys have put into this issue. There are 360 pages and 2,371 footnotes in this issue, and I can tell you for certain that each and every one of them got the time and attention that they required and deserved. I might be the one up here speaking, but this was truly a collective effort, and I couldn't have done it without you. And of course, there's the executive committee. I am constantly blown away by your dedication and your brilliance, and I'm eternally grateful for your friendship. Whether I'm in need of a laugh, some AGLC guidance, or just someone to work next to me in the office, I know I can always count on you to provide it. Thank you for being beacons of light in the often treacherous waters of editing, and always greeting me with a smile, or, if I'm lucky, with a baked good. It has been the privilege of a lifetime to work with you all, and I will miss you all dearly. As my time on the executive committee comes to an end, I take comfort in knowing that the journal will be left in your incredibly capable hands, and I cannot wait to see the new heights to which you take it. I save my final thanks for my friends and family. I'm extremely grateful to have my friends here tonight, because with how much I've talked about it, they probably think they edited this issue too. Thank you for your love, patience, and support throughout this journey. I am thankful every day to have met you, and I'm a better person for it. And I can't tell you how much it means to have had you in my corner for the past year. My family, of course, couldn't be here. It'd be a bit of a long commute. But I obviously would not be standing here without their unconditional love and support. From supporting my move to Sydney to pretending to understand the intricacies of citation rules, I can't put into words how much it means to have had such an incredible support network over the past year. They've been by my side, albeit from Canada, this whole journey, and I just hope I made them proud. And now, for the moment you've all been waiting for, it is my absolute privilege to introduce the keynote speaker for the evening, the Honorable Marcia Neave. I could do another 15 minutes just talking about Justice Neave's career, but I think I'm already over time, so I think I'll try to keep it to a minute or two. Justice Neave has long been an advocate for greater access to health, law, and justice, dating from 1985, when she chaired the Victorian Inquiry into Prostitution, to 2016, when she chaired the Royal Commission into Domestic and Family Violence, to 2021, when she was appointed president of the Commission of Inquiry into the Tasmanian government's responses to child sexual abuse in institutional settings. Justice Neave has served on state law reform commissions in New South Wales and Victoria, and now serves as a part-time commissioner of the Australian Law Reform Commission, as well as chair of Justice Connect. If that wasn't all impressive enough, she also served as a justice of the Victorian Court of Appeal for 9 years, and was actually the first academic in Victoria's history to be appointed to the bench. In recognition of all of these achievements, Justice Neave was made an Officer of the Order of Australia in 1999 and was awarded the Centenary Medal in 2001. In light of all of that, I would find it extremely hard to believe that there is anyone more qualified to speak about this issue's theme. And we are very lucky to have her here tonight. So with that, please join me in welcoming the Honorable Marcia Neave.
Thank you so much, Jack, for that very kind welcome. And also, I've had a lovely time this evening walking around talking to members of the editorial committee, contributors to the journal, and other colleagues and friends. So thank you very much for that. And thank you also for the invitation to launch Volume 47, Number 3. It was a delight and a surprise to be asked to do so. I should start by acknowledging that we're meeting on the land of the Gadigal people of the Eora Nation and paying my respects to elders past, present and emerging. Now, I was going to start by providing a bit of an overview of the contents of the journal, but that has already been done so beautifully by Jack and the other speakers that I'm not going to repeat what he's already said. I loved your metaphor, comparing the process of putting the journal together with a jazz band, and I thought that just worked brilliantly. And the dilemma that you had about how you were going to pull all this together was also a dilemma that I shared. What's the theme that I can use to pull all of this together? So I'm not even going to try, although I've got notes on this in my speech, I'm not even going to try to repeat some of the things that you said and the wonderful description of what's in the contents of this journal. When I looked at it, I thought this is an amazing menu. And I started by thinking that I might provide you with some brief hors d'oeuvres, indicating just a little snippet of what was in there. But I think you've done that so well, and using that musical metaphor to link it all together, that I'm not going to go there. So what I will do is go straight to what the other theme in my talk, which is, I think, how law journals such as the University of New South Wales Law Journal and legal scholarship in general contribute to access to justice, to law reform, to legal and policy reform. And I will give a few examples as I go through by referring to some of the journal articles. But basically my argument, I think, is that journals such as the University of New South Wales Law Journal are enormously important in contributing to the development of the law and in contributing to addressing issues of injustice, unfairness, both in the substantive law and in legal practice. So that's what I'm going to go to. I've just chucked out the first 3 pages. So this will be much shorter than you expected and you'll be able to get to dinner more quickly. Okay, so I should say also, before I start to talk in more detail about this, that I have always admired the University of New South Wales Law Journal because of that commitment, the reference that was made to Hal Wooten, whom I knew, that commitment to thinking about how work of this kind and how the work of law schools can address issues of serious social injustice. And one of the things I like particularly about the University of New South Wales Law Journal is it's an open access to journal. It's not one behind a paywall. Anyone can read the articles in it, and I think that's really very important, and it's not a feature of all law journals in Australia. So let's talk a bit about how legal scholarship can contribute to law reform. So we know the main bodies in Australia that contribute to the development of legal and social policy. One-off inquiries, standing law reform bodies such as the Victorian and New South Wales Law Reform Commissions, Royal Commissions, all play a part in developing legal and social policy. So those are the areas in which I have worked off and on throughout much of my career. All of those bodies have tasks which are defined by terms of reference, but of course law reform commissions don't have the same broad powers to compel individuals to give evidence as the powers of royal commissions. Some royal commissions are established to identify the reason that something terrible has happened, to identify the cause of a current problem, for example, whether there's corruption in a particular organisation, a matter which is relevant at the moment. But even and some royal commissions are established to talk primarily about issues of policy, and I go back a long way to think about the Royal Commission on Human Relationships in the 1970s, which was an example of that. But both types of royal commissions certainly make policy recommendations. And the work of those royal commissions is quite similar to the work of law reform bodies, such as the University of New South Wales or Victorian Law Reform Commissions. I think there are at least 4 ways in which legal scholarship and publication can improve the work that is done by those bodies. First of all, they can do so by identifying areas of injustice, and Jack has spoken quite a lot about that. Secondly, by examining solutions, contributing to the development of coalitions for change, and that's something which is not always considered or talked about. By analysing, comparing legislation, by evaluating the effects of past reform, and by bringing together social science insights with the work of lawyers. So I'm going to say a little bit about each of those areas. So beginning first with looking at areas where the law or practice, and when I say the law, it could be case law or legislation, creates injustice. That's an area where legal scholars have always worked, but as I've said, the University of New South Wales Law Journal, I think, has been a particularly strong contributor in that area, and this journal is an excellent illustration of that. And I've referred already to the open access policy. So I think this is a trend now in legal scholarship, which is probably stronger than was the case when I was case note editor at the Melbourne University Law Review about a very, very long time ago. That emphasis on fine-grained doctrinal analysis, where you unpick the things that judges say in particular cases, I think is less a feature of law journals, and particularly of the University of New South Wales Law Journal. And what we now have is much greater emphasis on solving real-life problems of access to justice. Often that legal scholarship ends up being combined with activism to highlight examples of unjust laws. So academic writing can provide a compelling argument for change, and sometimes the work that's done by academics is picked up by activists and can provide a basis for putting pressure on governments, for lobbying bodies to address those areas of reform. And just to give you a few examples, over the last 50 years or so, feminist legal scholars have exposed the way that laws that treat men and women identically can reinforce disadvantage and discrimination. And I might refer to a terrific book which has just been published which is called the Feminist Project on Legislation, edited by Battergol and others. It's a collection of articles which look at legislation and say, well, how would you deal with this how would you change legislation if you were thinking about the issues that are confronted by women? That's just one example, and that sort of research, I think, has been and is featured in this journal, but has been around for some years. Other areas are other areas of legal scholarship are increasingly considering how the law affects Indigenous people, how the law affects people who have a physical disability, how the law affects people who have mental illnesses, how the law affects people with diverse gender identities. And all of those areas are addressed in this issue of the journal. The importance of the publications in that area is that they expose, they make visible legal inequalities, which I think were not previously recognised by many lawyers. Both the Royal Commissions in which I've been involved were prompted by widespread criticism of the way the law has dealt with areas of serious injustice, which were originally exposed by a combination of legal writing and activism. Areas like family violence, areas like the institutional abuse, sexual abuse of children, are areas which have been exposed in law journals such as the University of New South Wales Law Journal. So that's my first area of contribution. Second area of contribution is looking at solutions to those problems, putting forward proposals and helping to develop coalitions for change. And I've referred to the combination of legal writing and activism, but that notion of developing coalitions, people who can bring pressure to bear on government, I think is very important. One of the things that academic writing often does is to unpick and define problems with a greater degree of precision than usually occurs in common discourse. And just again, to give you some examples from my experience, terms of reference for both law reform bodies and royal commissions are often quite generic. They're very broad. They don't highlight the particular areas that need to be addressed. And one of the things that academic writing and contributions to journal articles can do is identify the areas that can be examined in detail and those which can be looked at more cursorily. One of the things that I've done when I've worked in law reform at the beginning of the project has always been to map the terrain. Do a map which identifies what the issues are and what are the possible areas where you could think about change. Law journal articles, I think, are absolutely vital in that process. And I also would say that in the past, I've often had conversations with authors of articles to expand upon and understand the arguments that they're making. And that has been a helpful process, I think, because otherwise the problem can look too big, a bit like the problem that you were talking about, Jack, in writing your excellent speech. How do you take this huge area and unpick it? And I think that's something that legal scholarship can do. The other area, which is sort of goes in the opposite direction in a way, is that legal knowledge is often pigeonholed. People have an expertise in one area or another. For example, and this is using some of the areas that I've worked in, criminal law scholars may not have much expertise on civil remedies for wrongdoing. Family law scholars may not know much about the processes which apply in state courts in relation to intervention orders, or I think they're called something else different here. I've lost the words, but there's a description for them in New South Wales. But law reform bodies often have to look across legal boundaries if they're going to address what are sometimes called wicked problems. Wicked problems are problems where you've got lots and lots of different issues that have been looked at, sometimes piece by piece. They're not brought together, but if you want to do good law reform, you often have to think about the relationship between this area and another area of the law, which appear on their surface to be disconnected. And I think that that's something that legal scholars can do if they break out of the boundaries that are imposed on them by their area of expertise. And just to give you an example, the Australian Law Reforms Commission's reference on harmonising sexual offence laws requires the Commission to consider how victims, survivors of sexual assault are dealt with in the criminal justice system, but then also to think about areas like employment law, civil damages, restorative justice approaches. And I think it's very important for Law Journal articles to do that too, to suggest that there are links between different areas and how those links and sometimes inconsistencies can be brought together. The third area, and I think this volume of the journal is particularly strong in doing this, is the whole question of analysis and comparison of legislation, whether it's working, what its limitations and restrictions are. And that is, in the case of some journals, fairly new. Not so for the University of New South Wales Law Journal. But I recall an observation by Justice Michael Kirby, who was talking about the sort of writing that was done when he was a law student. He said, and this is a quote, "The distinctive feature of contemporary Australian law derives from the overwhelming importance of the laws made by or under Parliament." He contrasted that with the situation in his youth, where the statutory law of the state of New South Wales was collected in 12 manageable volumes, supplemented by a 3-volume index. By contrast, now, Australian law is largely legislatively based. And what I really liked about this volume of the journal is the discussion of the strengths and weaknesses of particular state acts, and also the cross-jurisdictional comparisons which are contained in the journal, so that Victoria can learn from New South Wales, Queensland can learn from Victoria, etc., etc. I also like that approach because it shows that the Australian legal system and discussion and legal scholarship has really abandoned the colonial cringe, which I think was a feature of Australian society when I was a law student, where there was a huge amount of reference to English law, United Kingdom court decisions. So Jack has already referred to some of these, but the articles by Wolfe, by Wangman, by Generay and others all fall into this category. They're all analyses of legislation which in some cases cross boundaries into other states. Another example is Duffy and Lombard's article, which examines the controls which govern litigation funding in the context of insolvency claims and third-party litigation funding. This has particular pertinence in my state, Victoria, where a leading silk recently conceded he should no longer be able to practice law because of his involvement in very large class action litigation. Another example, which again could be something which could be drawn upon in other states, both the strengths and weaknesses of the New South Wales legislation, is Lingard's article, which looks at the New South Wales Criminal Crimes Appeal and Review Act, under which a person who says that they were wrongfully convicted of an offence can apply directly to a judge, acting in a non-judicial capacity, to provide a report on the conviction, different from the process which exists in many other states where this is an executive role. The matter can be referred by the executive, discussed by the executive, but in this case, it's quite a different approach, and the article provides a very important insight, I think, into the usefulness of that approach. Commentators who defend federal systems often argue that states should be regarded as laboratories for experimentation, which enable the testing of different approaches. And that can work in a number of different ways. One way in which it can be beneficial is that Australian legislators learn from each other. by enacting similar or identical legislation. And an example of that was the work that was done by the New South Wales Law Reform Commission a very long time ago, dealing with the division of property between people living together in what were then called de facto relationships. And that was extremely controversial at the time, but that legislation then formed the basis for legislation in other states and its extension beyond heterosexual relations to cover, for example, same-sex relationships. So in that case, the laboratory model worked very nicely. The other way the laboratory model, or the different state model can work, unfortunately, is it can also reveal resistance to reforms which have been enacted elsewhere without any major difficulty. I'm working on the harmonisation of sexual violence laws at the moment at the Australian Law Reform Commission, and there we're being asked to look at state laws, consider the extent to which they're trauma-informed, make recommendations about areas for change. Now, in that area, we're having to deal with uniform evidence laws, which apply in New South Wales, Victoria, ACT, Northern Territory and Tasmania. But only some states haven't adopted those laws, and one of the things that journal articles can do can attempt to expose the implications of those differences. Of course, policy makers have to take account of differences in the resources and context in which lawyers in different states operate. I can't help thinking, however, that conservatism sometimes blocks worthwhile reforms. Lawyers often are very happy to continue with the areas in which they've worked in the past and the way that problems are resolved, have been resolved in their jurisdiction, and not want to have to go through the process of thinking again about how you do it differently. I did mention the fact that we used to look a lot to UK law, and I think it's a healthy trend in this journal and in earlier editions of this journal that there is a comparison of legislation in different states. But of course, we can also sometimes learn something by looking at how overseas jurisdictions have responded to a law reform problem. And that's apparent in some of the articles in this journal. We can look at the way New Zealand, Canada, the United Kingdom have dealt with similar issues and learn from it. And that's something that's very important for law reform commissions. And that's an area where I think legal scholars can make an important contribution. They can identify overseas innovations. I've been thinking a little bit about the way Canada deals with some of the issues that arise in the context of the criminal law, and of course criminal law is not provincial in Canada, it's federal law, but it's useful to think about that. For the next area, and I hope I've got my numbers right now, I think it's number 3, sorry, evaluating the effects of past reform. And one of the things that I think about a lot, because of my interaction moving in and out of law reform, is the extent to which it's not a one-off process. It's iterative. Sometimes something that looks as if it'll work quite well doesn't do so. Sometimes a reform doesn't meet its goal, sometimes it produces unintended effects. And Law Journal articles can point out when this occurs, suggest when further changes should be made. I think that the article by, and I'm sorry I haven't indicated the first name, by Wangman, whom I spoke to before, I've forgotten her first name, the article that she's written about the New South Wales coercive control legislation, and she points out that it's not working. One of the reasons it's not working is because it's based on a misunderstanding of the nature of the problem, and that's the sort of exposure that can be made in a Law Journal article and can provide the impetus for further reform. Another article which I found particularly interesting is the article by Hamer, which looks at how courts analyse the language of probative value which is used in the sections in the Uniform Evidence Act, and Jack referred to that too. And I think you can draw two things out of that article. One is this is relevant to some very important questions in the criminal law. In the jurisdictions which have uniform evidence laws, it's relevant to the question whether tendency and coincidence evidence can be led in criminal prosecutions, and whether, for example, in cases involving child sexual abuse, evidence about prior examples of abuse by the alleged perpetrator can be admitted in evidence. Very important question, and the article by Hamer discusses how courts have tended to approach that issue, certainly relevant to the work that I'm currently involved in with the harmonising sexual offence laws. The other thing that article, I think, illustrates is the question of legal culture and the relationship between legal culture and reform outcomes, and I think that's implicit in a number of pieces in this journal article. And finally, I think, the other thing that I think this issue of the journal does, and which I think is extremely important, is law journals are increasingly publishing articles which use both qualitative and quantitative social science research techniques to assess how the law is actually working. That's not so much for UNSW Law Journal, which has done that in the past, but I think this is a strong example of that. Historically, law and policy reform has been hampered by inadequate data on how particular legislative provisions or common law principles actually work. We still have very limited statistics providing insight into the operation of particular legislation or common law principles. And I'll give you an old fogey anecdote. In 2004, the Victorian Law Reform Commission had a reference on sexual offences. At that time, the only source of information on trial outcomes, these were cases which were reported and actually went to trial, small proportion of the cases in which sexual offences had been reported. The only data was a sheet of paper, I think it was before Excel, so it wasn't even a spreadsheet, a sheet of paper on which a particular prosecutor recorded the names of the cases and whether there'd been a conviction or acquittal. He did it for his own interest. We called the data, we christened that data with the name of the prosecutor. I won't tell you what it was, but he had a name and we called it by his name. And that was the data that we had, which was shocking. Now, things have improved a lot, but this is still an area where there is a serious dearth of information, particularly in the smaller states. It's one of the areas that state governments tend to cut when they're financially stretched, particularly, again, as I said, in the smaller states. Academics working with law reform bodies on particular topics, I think, could help to develop that data. I'd like to see closer relationships created between courts, bodies such as judicial commissions, legal scholars, law reform bodies, to identify information which can throw light on questions where you're considering reform. And you hear you often hear in law reform, very dogmatic statements about how the particular area of law works, based on a belief, and to some extent on experience, and that can be very helpful, but you need to test those beliefs and experiences. In areas of uncertainty, judges often point to the effects of a particular interpretation of words in a statute, or in deciding whether a common law principle applies in a novel situation. it's sort of consequential reasoning. If we reason this way, this is what will happen. If we reason that way, if we've got a choice, we can choose between these two possibilities. Academics do the same to some extent in order to criticise conclusions reached by courts. But often that sort of reasoning is largely speculative. It's based on speculation about how people think that particular approach will work. That's why we need more combination of social science techniques, for example, statistical analyses of court processes and decisions, qualitative surveys, and there are some in this journal, which look at how people are actually affected by the way in which the law operates. So I like to think about the way that lawyers can work with social scientists, and I like to think that increasingly in the future, law journals will do more of that sort of work. And maybe we should be thinking about how we draw on the experience of law students in other disciplines. So I really welcome that trend, which is evident in the University of New South Wales Law Journal. Of course, interdisciplinary scholarship is very challenging. We think in different ways. It's not an easy process for social scientists to work with lawyers. But I would like that trend, which, as I said, is apparent in this volume of the University of New South Wales Law Journal, to be developed even further. I did have a whole lot of congratulatory and commendatory comments to make about the journal and the wonderful work that many people have done on it, and the imagination that this volume of the journal shows. I think Jack stole my thunder on that, as on many other things. And that, your speech was wonderful, Jack. That's not a criticism. It was an excellent speech, and I think you said it all for me, so I'm not going to repeat that. I just want to conclude by congratulating Jack, all members of the editorial board, all members of the journal, and the contributors for what you've produced. I should say that as a busy person, I usually look for journal articles which deal with the topics that I'm working on. I don't sit down and read, and I think I'd be very strange if I did, sit down and read a law journal piece from a law journal from cover to cover. But I did so in this case, I needed to. And I learnt a huge amount by doing so in some of the areas that I'm particularly interested in, but also in other areas. And I started to think about connections between areas that I'm working on currently and other articles in the journal. So I think that everyone involved in the production of the journal should be congratulated for the emphasis that it gives to improving and evaluating the law, to provide access to justice, to give more power to the powerless, to inspire people to work who are concerned about injustice, who are not necessarily lawyers but often are, to work together with scholars. I would really like to congratulate that emphasis in the journal. And all I can now say is keep up the good work, and I'm sure that you will, and your successor will, Jack. Thanks very much.
Well, good evening. My name's Andrew Lynch, and I have the great pleasure and honour of being the Dean of the Faculty of Law and Justice at UNSW. And it's my role tonight to say a very few brief thank yous and congratulations before handing back to Sharanya to wrap things up. My official duties are, of course, to give a vote of thanks to our wonderful guest speaker, the Honourable Marcia Neave, for her remarks and official launching of Volume 47, Issue 3 of the UNSW Law Journal. And I really admired and am very grateful for the remarks that were offered tonight, Marcia, because I thought you did three things simultaneously with great elegance. You certainly played to the room by talking about the great importance and value of law journals. We're all here for that. And I thought that was a very safe but important topic. And the message around the role of journals in exposing injustice and providing solutions, and the way in which they do so and their utility was incredibly important. Thank you for that. But whilst you did that, of course, you seamlessly wove through the contents of the issue itself to provide examples of the very points that you were making. And the third thing that you did, and which was so wonderful, was to highlight your own professional experiences and also, dare I say, your experiences as a student and how that had affected your reading of the journal and the points that you were making about its value. So you were very generous in all that you gave us to think about tonight, both from your personal experience but also your great erudition and thought on the role that journals have to play, which is extremely affirming, of course, for those who work so hard on bringing them into being. Thank you very much for joining us tonight. It was a great honour to hear your remarks. On the topic of access to health, law and justice, I actually wanted to point out an event that I am attending next week in terms of what the faculty is doing in a quite different way to deliver on this important ideal. The Kingsford Legal Centre of UNSW, which has existed since 1981, has for the last 5 years been engaged in a thing called the Health Justice Partnership, which has involved a solicitor and student volunteers up at the Randwick Hospital, actually providing legal services to the vulnerable members of our community local to the university. And the event that I'm speaking at with the Dean of Medicine is to launch a 5-year review of the success of that partnership, tallying the numbers of clients served, the kind of matters dealt with. That is all, of course, on the cusp of the Kingsford Legal Centre opening up a sort of branch office, if you will, in the new health translation hub that UNSW will occupy in the Randwick Health Innovation Precinct. So there's an enormous amount of excitement at the university in terms of how law and medicine and health are working together in that and amongst other ways, really to ensure that access to health is something that we can assist and have a pivotal role in supporting as lawyers and those interested in justice in our community. I also want to thank, as sponsors of the journal, Allens, along with other premier sponsors. Their steadfast support over several decades has been really remarkable and is incredibly appreciated, not just by the journal team itself, but the faculty that sits behind them, or alongside them, I should say. And I also want to thank Simon for his remarks tonight and for making us welcome as host. Simon had other options for tonight, of course. He could have been running in the JP Morgan Fun Run. I think he was quite glad to have the excuse not to perhaps do that. But he also could have been on the cliffs of Bondi to Bronte, looking at Sculpture by the Sea. He's a very dedicated member of the Faculty's Advisory Council, so of course there was no contest, and it was wonderful to have you here with us tonight, Simon. I also want to thank my colleagues in the faculty who are here. I really appreciate each and every one of you being here and showing your support and pride in our students and the journal that they produce. I know it means a great deal to them, and it does to me also. I think this point has been touched on, but the UNSW Law Journal is an independent journal, and I really always want to emphasise that. There are faculty advisors, Roz and Gary, who do a great job, but the journal that you're collecting an issue of tonight is entirely the product of the contributing authors, and congratulations to all of them, particularly those who have joined us tonight. But everything that happens, I've forgotten how many footnotes you said and how many pages, but all of that is generated by our students. And the faculty just has the great joy and pleasure of the reflected glow of that strong reputation that our students carry forward into the world, and we're enormously grateful. I thank every member of the team that has worked so hard to bring the issue into our hands tonight. And I also thank and love at these events when former, what I call UNSW Law Journal alum, actually make their way from their office in the host firm or have trekked across town to join us, and there's a few here tonight, and that's incredibly special. There is a real community in the journal. Jack spoke about how it has carried him through the unique experiences of being issue editor, and that tie never dissolves. Once a member of the UNSW Law Journal, the experience seems incredibly formative, and it's really great to see people who have graduated to come back and support those who are doing the roles they held. And now, of course, I thank the executive team led by Sharanya. It's really been an incredibly successful year for the journal. There's one more issue to go. Rowan's excited about 11 December, as are all of us. But the team has worked so well together and to produce the 3 issues with one more to come. But Jack, it's really your night as well. So congratulations to you as the issue editor. Your number will always be 47.3. It will, if you catch a bus or anything, that you'll have flashbacks, I'm sure, to the experience of the journal, the highs and the lows and the challenges and the great joy. I was very excited to learn this phrase, good enough for jazz. I don't know that phrase, and I actually am quite a jazz fan. And I was extremely excited and a little nervous when you said, I'm going to go out on a limb, and I thought you might start scatting or something, because anything can happen at a journal launch. But I thought your analogy was a perfect one. I have actually once read a US paper which was about multi-member courts and jazz improvisation and harmony, so I didn't have to do a huge leap to see what an apt analogy it was, really, to talk about the experience of bringing the journal into being, to be very similar to being in a jazz ensemble. This is more than good enough for jazz. This is excellent. Congratulations. Thank you to you and all the many people who have contributed to the issue. And I now hand over to Sharanya to close.
Thank you so much, Professor Lynch, for that wonderful vote of thanks, as always. And thank you so much, Judge, for your incredibly insightful and informative keynote address. With Volume 47, Issue 3 of the University of New South Wales Law Journal officially launched, we have now reached the conclusion of tonight's proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please don't forget to collect a complimentary copy of the journal on your way out. All of the articles of this issue can be found on the Law Journal's website now. Thank you all so much for coming tonight, and I hope you enjoy the rest of your evening.